What is a common carrier? Common carriers are persons, corporations, firms, or associations engaged in the business of carrying or transporting passengers or goods, or both, by land, water, or air, for compensation, offering their services to the public. Article 1732 of the Civil Code. Example: William makes regular trips to Bohol using his 4-passenger truck to pick up the produce of his small bee farm. To help offset the cost of gasoline and tolls, about a week before he makes a trip, he posts on social media advertisements looking for 3 persons who need a ride to Bohol, or who from Bohol would like a ride to Baguio. In exchange, he only asks for an equal share of cost of the gas and tollway fees. The posts are public posts. One of the trips, William got into a collision, and one of his trip companions got injured. When the latter sued him for damages as a common carrier, William argued that he was merely a private carrier. He points to the fact that he does not have a certificate of public convenience. Is William correct? No, William is a common carrier. A party is a common carrier when he or she is engaged in the business of carrying persons or goods as a public employment and must hold himself or herself out as ready to engage in such transportation of persons or goods, generally as a business and not as a casual occupation. Article 1732 of the Civil Code makes no distinction between one whose principal business activity is the carrying of persons or goods, or both, and one who does such carrying only as sideline. The article does not make any distinction between a person or enterprise offering transportation service on a regular or scheduled basis, and one offering such service on an occasional, episodic, or unscheduled basis. Neither does the article distinguish between a carrier offering its services to the general public and one who offers services or solicits business only from a narrow segment of the general population. De Guzman v. CA, GR 47822, December 22, 1988. Spouses Cruz v. Sun Holidays, GR 186 312, June 29, 2010. In this case, William offers to transport any person from the general public who wishes to go to Bohol or to go to Baguio. He does so as a regular business, even if his fee is only sufficient to cover the costs of each trip. The fact that he is not a holder of a certificate of public convenience does not mean that he cannot be deemed to be a common carrier. Are pipelines that transport petroleum products from refineries to another included in the term common carrier? Yes. The definition of common carriers in the Civil Code make no distinction as to the means of transporting, as long as it is by land, water, or air. It does not provide that the transportation of the passengers or goods should be by motor vehicle. First Philippine Industrial Corporation v. CA, GR 125 948, December 29, 1998. William rides a car via ride-hailing application, Grabber. As they were traversing a curve, the Grabber car crashed, which caused severe injuries to William. William now comes to you asking whether a Transportation Network Vehicle Service, TNVS, or Transport Network Company, TNC, such as Grabber, is considered a common carrier? Decide. Yes. The LTFRB issued Memorandum Circular Number 2015-018-A on October 23, 2017, where it appears that TNVS are deemed to be common carriers. TNVS and TNC are defined in DOTC-DO number 2015-11 as a business organization that provides pre-arranged transportation services for compensation using internet-based technology application or digital platform technology to connect passengers with drivers using their personal vehicles. Moreover, TNVS operators ordinarily exercise a significant amount of control and supervision over the conduct and performance of its so-called partner drivers. Thus, the certificate of public convenience is issued to the TNVS and not the individual drivers, with the TNVS operator having the requisite obligation of only allowing accredited drivers to participate in its platform. The accountability of TNVS attaches from the time the TNVS is online and offers its services to the riding public. Thus, Grabber possesses all the liabilities of a common carrier and is considered as such under Philippine law. Kung Fu Panda is a mobile app which takes orders on behalf of food establishments that, after placing the order, calls upon third-party drivers who provide the service of picking up the food at partner establishments, paying for it with their own money, and delivering it to the customer. On a hot summer day, Kokai ordered milk tea and a snack from Super Tea through the app. Then William, a driver who wears a helmet bearing the Kung Fu Panda logo, was called upon to pick up the order from Super Tea and deliver the same to Kokai within 30 minutes. Super Tea placed both the drink and the snack together inside a paper bag. William then put the bag inside an insulated box to ensure that the summer heat would not melt the ice in the drink. William wasted no time in getting the order to Kokai. Nonetheless, the ice in the drink had completely melted and the snack had become soggy since it was placed inside the same bag as the ice drink. Kokai now demands that Kung Fu Panda comply with the terms of the contract at its own expense as a common carrier. A. Kung Fu Panda claims that William was an independent service contractor who engages in the business of common carriage, and it merely brokers delivery orders on behalf of the users and the food establishments. Thus, William is the party liable as he is the common carrier. William counters that he is merely an employee of Kung Fu Panda, who is the common carrier. B. Whoever the court determines to be the common carrier, both Kung Fu Panda and William raise the defense of the inherent defect in the packaging of the goods to avoid liability. Will the defense prosper? Letter A. Kung Fu Panda is the common carrier. It is engaged in the business of carrying goods from food establishments to its user for free and holds itself out as ready to engage in said transportation of goods as a business. 1732. William is merely an employee or agent of Kung Fu Panda. William is not an independent contractor since he does not offer the delivery service to the public in general but only to those who order food using the Kung Fu Panda application. He bears the logo of the Kung Fu Panda on his helmet when he works, and his conduct and performance is generally under the control and supervision of Kung Fu Panda, such as the efficiency of his delivery. He receives payment on behalf of Kung Fu Panda and merely returns a part of it as his piece rate wage. Thus, as between Kung Fu Panda and William, it must be Kung Fu Panda who must bear the loss and compensate Kokai. B. Yes, the defense will prosper. William, as employee of the common carrier, did not fail in exercising extraordinary diligence. Article 1734 of the Civil Code provides that common carriers are not liable in case the loss, destruction, or deterioration of the goods is caused by the character of the goods or defects in the packaging or in the containers. Since it was a hot summer day, the ice in the drink will naturally melt. Further, the snack, losing its crisp and turning soggy, was not due to the negligence of William, but rather because of the way Super T packed it together with the iced drink in only one paper bag. Moreover, although the packaging of the goods was inherently defective, William exercised due diligence to forestall or lessen the loss. 1742. William put the ordered items inside an insulated box to ensure that the heat would not melt the ice in the drink. Despite these efforts, the ice in the drink still melted. This is a valid defense. L Company provides train services for a fee. Commuters are required to purchase tickets and then proceed to designated platform to board the train. William purchased a ticket and entered the station. While waiting, he had an altercation with the security guard of L Company, leading to a fist fight. William fell on the railway just as the train was entering the station and was run over by the train. In the action for damages filed by the heirs of William, L Company interposed lack of cause of action, contending that the mishap occurred before William boarded the train and that it was not guilty of negligence decide. L Company is liable. It is a contract of carriage with William, created from the moment the latter purchased a ticket and entered the station. The duty of a common carrier like the L Company is to provide safety to its passengers, not only during the course of the trip, but as long as they are within its premises and where they ought to be in pursuance to the contract of carriage. Light Rail Transit Authority versus Navidad, GR 145804, February 6, 2003. What is the presumption when goods transported by a common carrier are lost, destroyed, or deteriorated? In all cases other than those mentioned in numbers 1, 2, 3, 4, and 5 of Article 1734, if the goods are lost, destroyed, or deteriorated, common carriers are presumed to have been at fault or to have acted negligently, unless they prove that they observe extraordinary diligence as required in Article 1733 of the Civil Code. Does the common carrier have any defense with respect to damage or loss in the carriage of goods? Common carriers are presumed responsible for the loss, destruction, or deterioration of the goods unless the same is due to any of the following causes only: flood, storm, earthquake, lightning, or other natural disaster or calamity. B. Act of the public enemy in war, whether international or civil. C. Act or omission of the shipper or owner of the goods. D. The character of the goods or defects in the packing or in the containers. E. Order or act of competent public authority. Article 1734. A vessel owned by carrier BB was loaded with cargo in Japan for delivery of the same to Romeo. Once loaded, the vessel set sail for Manila. The cargoes were placed in a hatch and only inspected once while in Japan. En route to Manila from Japan, the vessel caught fire and sank, resulting in the total loss of ship and cargo. According to the statement of the crew of the vessel, the fire started in one of the hatches where the cargo bound for Manila was stored. At the time the crew noticed the smoke and discovered the fire, it was already too big to extinguish. Further, the crew claims that the fire started at least 24 hours before its discovery. Romeo filed suit against BB to recover the value of the lost cargo. BB, however, denies liability mainly on the ground that the loss was due to an extraordinary fortuitous event. BB claims that the fire falls under the phrases natural disaster and calamity, as found in Article 1734 of the Civil Code. May the fire in this situation be validly considered as natural disaster or calamity exempting BB from any liability? No. The fire may not be considered a natural disaster or calamity. This must be so, as it arises almost invariably from some act of man or by human means. It does not fall within the category of an act of God unless caused by lightning or by other natural disaster or calamity. And even if fire were to be considered a natural disaster within the meaning of Article 1734 of the Civil Code, it is required under Article 1739 of the same code that the natural disaster must have been the proximate and only cause of the loss, and that the carrier has exercised due diligence to prevent or minimize the loss before, during, or after the occurrence of the disaster. BB's lack of diligence is shown in that when the smoke was noticed, the fire was already big, that the fire must have started 24 hours before the same was noticed, and that after the cargoes were stored in the hatches, no regular inspection was made as to their condition during the voyage. The foregoing suffices to show that circumstances under which the fire originated and spread are such as to show that BB and its employees were negligent in connection therewith. Having failed to show that they exercised the required extraordinary diligence, BB is liable for the loss of the cargo as a result of the fire. Eastern Shipping Lines versus IAC, GR 69044. What is the presumption in case of death of or injuries to passengers? In case of death of or injuries to passengers, common carriers are presumed to have been at fault or to have acted negligently unless they prove that they observe extraordinary diligence as prescribed in Articles 1733 and 1755 of the Civil Code. Article 1756. During a bus stop conducted by driver Fredo to check the condition of the tires of the bus, Tino, a passenger in the bus, was surreptitiously shot in the head by a co-passenger. The bus is owned by Lion Bus. The heirs of Tino contended that 1. Lion Bus and Fredo are civilly liable for the death of Tino as a common carrier, and 2. Lion Bus and its employees were bound to observe extraordinary diligence in ensuring the safety of passengers by checking that weapons are not brought on board, and 3. The mere fact of Tino's death raises the presumption of fault under Article 1756 of the Civil Code. In their defense, Lion Bus and Fredo maintained that they had exercised the extraordinary diligence required by law from common carriers. During the day of the incident, neither Fredo nor his conductor observed anything suspicious from the passengers to warrant any bodily inspections. There was no sign of immediate or future threat that could have been avoided. Lion Bus claims that Tino's death should be properly deemed a fortuitous event. Are the contentions of Lion Bus and Fredo correct? Yes. They cannot be held civilly liable for the death of Tino. Article 1763 of the New Civil Code provides a lesser degree of diligence when assessing the existence of any culpability of the common carrier, where a passenger sustains injury due to the willful acts of a co-passenger or stranger. Tino's death was neither caused by any defect in the means of transport or in the method of transporting, or to the negligent or willful acts of Lion's Bus employees in their capabilities as driver and conductor. Instead, the death of Tino was wholly caused by the surreptitious act of a co-passenger. Fredo and his conductor observed nothing which would rouse their suspicion that the perpetrator was armed or was planning to carry out an unlawful activity, as to prompt them to conduct a more stringent search, that is, bodily search. Therefore, Lion Bus and Fredo may not be held civilly liable for Tino's death. DV Florida Transport versus Heirs of Baton Jr. GR 208802, October 14, 2015. When can a common carrier raise or not raise due diligence in the selection and supervision of employees as a defense? Where the action is based on the contract of carriage, due diligence in the selection and supervision of employees is a defense provided that due diligence means extraordinary diligence, except in the case of carriage of goods, and there is a valid stipulation lowering the standard of diligence to that of good father of a family. Articles 1735, 1744, 1759. The common carrier's liability in these cases is based on the principle of respondeat superior. Where the action is based on quasi-delic, due diligence in the selection and supervision of employees is a defense under the last paragraph of Article 2180 in relation to Article 2176 of the Civil Code. The common carrier's liability as employer is based on the principle of bonum pater familias. Where the civil liability of the employee arises from crime, and where the employer is charged with his subsidiary liability under Article 103 of the Revised Penal Code, due diligence in the selection and supervision of the employee is not a defense. Caesar, together with his daughter Juliet, boarded a bus owned and operated by Brutus. After Caesar and Juliet had alighted during one of the stops, Caesar realized that he left behind his bayong and went back to the vehicle, instructing Juliet to wait by the sidewalk. He did not notice, however, that Juliet disobeyed. While Caesar was standing on the exit door of the bus waiting for the conductor to hand him his bayong, the bus, whose motor was not shut off while unloading, suddenly started moving to resume its trip. With that, Caesar immediately jumped from the exit without getting his bayong, but saw that Juliet was lying prostrate on the ground with her skull crushed and without life. Caesar claims that it was the negligence of the driver that caused the death of his daughter Juliet. A. Did the contract of carriage terminate as soon as Caesar and Juliet alighted from the bus? Can the bus operator raise as defense that he had exercised the diligence of a good father of a family in the selection and supervision of his employees? C. Can the bus operator be held liable for the negligence of its driver even if the contract of carriage terminated? A. No. The contract of carriage did not terminate. It has been recognized that the relation of carrier and passenger does not cease at the moment the passenger alights from the vehicle at a place selected by the carrier at the point of destination, but continues until the passenger has had a reasonable time or a reasonable opportunity to leave the carrier's premises. Thus, in this case, when Caesar returned to the bus for his bayong, which was not unloaded, the relation of passenger and carrier between him and the bus operator remained subsisting. La Mallorca versus Court of Appeals, GR L 20761, July 27, 1966. B. No. When the cause of action is based on the contract of carriage, Article 1759 of the Civil Code expressly provides that in the carriage of passengers, the liability of the common carrier cannot be avoided by proof of exercise in the diligence of a good father of a family. The liability of common carriers for death and injury of passengers requires a showing that the injury or death occurred despite the exercise of extraordinary diligence. And letter C, yes, even assuming that there was no longer a contract of carriage, the bus operator can still be held liable for the negligence of its driver pursuant to Article 2180 of the Civil Code. The facts show that despite being at the bus stop, the motor engine of the bus was not shut off. Also, res ipsa loquitur applies. The bus could not have moved without the driver being negligent, especially since he has full control of the same at the driver's seat. nor did Caesar contribute to his own damage. Macalino versus Ong, GR 146635, December 14, 2005. Thus, Caesar has a cause of action for quasi-delict against the bus driver. Consequently, the bus operator may be held liable under Article 2180 for the negligence of its employees. La Mallorca versus Court of Appeals, GR 20761. Is due diligence satisfied when an employer hires a driver with a valid professional driver's license? No. Due diligence in selection of employees is not satisfied by finding that the applicant possessed a professional driver's license. The employer should also examine the applicant for his qualifications, experience, and record of service. Due diligence in supervision, on the other hand, requires the formulation of rules and regulation for the guidance of employees and the issuance of proper instruction as well as actual implementation and monitoring of consistent compliance with the rules. Spouses Fabre versus Court of Appeals. Mark Anthony and his family boarded a bus, and along the trip, the front tire of the bus exploded. The bus fell into the ravine and struck a tree. The incident resulted in the death of Mark Anthony and physical injuries to other passengers. A complaint of breach of contract of carriage was filed by the family of Mark Anthony against the owner of the bus, Caesar, and the driver, Romeo. Both Caesar and Romeo raised the defense of casu fortuito and even contended that the branded tire was new, as it had only been bought and installed 5 days before the incident. Is the defense proper? No. The fact that the tire was new does not imply that it was entirely free from manufacturing defects or that it was properly mounted on the vehicle. Neither may the fact that the tire bought and used is of a brand name noted for quality result in the conclusion that it could not explode within 5 days' use. It is settled that an accident caused either by defects in the automobile or through the negligence of its driver are not considered a casu fortuito. Ubito versus CA, GR 113003, October 17, 1997. Romeo and Juliet were passengers of Z Airlines for a flight to Manila to Davao, not knowing that the flight was also boarded by Commander Octavio, with other members of a local terrorist organization who were able to smuggle aboard some improvised explosives and concealed bladed weapons. Using said weapons, they hijacked and directed the pilot to fly and land the plane in Zamboanga Airport for refueling. During a rescue attempt by the Philippine military, Romeo and Juliet were shot. Is the hijacking a casu fortuito, which would exempt the airline from liability? Yes. Applying the elements of a fortuitous event, the failure to transport the passengers safely from Davao to Manila was due to the skyjacking incident staged by the terrorist group without connection to the Z Airlines. Hence, the first requisite of a fortuitous event, which is that the cause must be independent of the human will, is satisfied because it is independent of the will of Z Airlines or its passengers. The events rendered it impossible for Z Airlines to perform its obligation in a normal manner, and it cannot be faulted for negligence on the duty performed by the airport police in screening the baggage of the terrorists as they entered the airport. The existence of force majeure has been established, thus exempting Z Airlines from payment of damages. Gacal versus Philippine Airlines, GR 55300, March 16, 1990. What is contributory negligence? Contributory negligence is the conduct on the part of the injured party, contributing as legal cause to the harm he has suffered, which falls below the standard to which he is required to conform for its own protection. Civil Code Article 2179, Sealoader Shipping Corporation versus Grand Cement Manufacturing, GR 167363 and 177466, December 15, 2010. What is the doctrine of avoidable consequences? The doctrine of avoidable consequences is when the passenger is also required to lessen the damage or injury even if the carrier is responsible for the loss or injury. Article 2203. Alexander went to the airport to catch his flight to Manila with X Airlines. However, their flight was canceled because of the ash fall from the Mount Pinatubo eruption, which blanketed Naia, rendering it inaccessible to airline traffic. X Airlines paid for their hotel expenses for their unexpected overnight stay, but the next day, the flight was still canceled and X Airlines stated that it would no longer defray their hotel and accommodation expenses. When they arrived in Manila, the passengers commenced an action for damages against X Airlines, claiming that the airlines have the obligation to ensure the comfort and convenience of its passengers. X Airlines claimed that the airline passengers have no vested right to these amenities in case the flight is canceled due to force majeure. A. What is assumption of risk? B. Does X Airlines have the obligation to shoulder the expenses and hotel accommodation of its stranded passengers until they have reached their destination? Answer to letter A. Assumption of risk is a rule that passengers must take such risk incident to the mode of travel because carriers are not insurers of the lives of their passengers. Thus, in air travel, adverse weather conditions or extreme climatic changes are some of the perils involved in air travel, the consequences of which the passengers must assume or expect. Japan Airlines versus Court of Appeals, GR 118664, August 7, 1988. B. No, X Airlines does not have such obligation. The event can be considered a form of a fortuitous event. Therefore, the delay was not imputable to X Airlines. The same case, Japan Airlines versus CA. Under the Air Passenger Bill of Rights, when the cause of delay is not attributable to the carrier, the only right of the passenger is to be reimbursed of the value of the fare. X Airline providing amenities is an act of gratuity on its part and is not a demandable right. What is the doctrine of the last clear chance rule? The doctrine of last clear chance provides that where both parties are negligent, but the negligent act of one is appreciable later in point of time than that of the other, or where it is impossible to determine whose fault or negligence brought about the occurrence of the incident, the one who had the last clear opportunity to avoid the impending harm, but failed to do so, is chargeable with the consequences arising therefrom. Stated differently, the rule is that the antecedent negligence of a person does not preclude recovery of damages caused by the supervening negligence of the latter, who had the last fair chance to prevent the impending harm by the exercise of due diligence. Green Star Express versus Universal Robina Corporation, GR 205090, October 17, 2016. And National Railways Corporation versus Vizcara, GR 190022, February 15, 2012. Does the doctrine of last clear chance apply to marine collisions? No, the doctrine of last clear chance isn't applicable for marine collision. The Supreme Court has ruled that for maritime accidents, it is Article 827 of the Code of Commerce that applies, and under said provision, the evidence disclosed that both vessels were blameworthy. The owners of neither vessel can successfully maintain an action against the other for the loss or injury of his vessel. C.B. Williams versus Theodore Yanko, GR 8325, March 10, 1914. What is an emergency rule? Under the emergency rule, one who suddenly finds himself in the place of danger and is required to act without time to consider the best means that may be adopted to avoid the impending danger is not guilty of negligence if he fails to adopt what subsequently and upon reflection may appear to have been a better method, unless the emergency in which he finds himself is brought about by his own negligence. Oryx Metal Leasing and Finance Corporation versus Mangalinao, GR 174089, January 25, 2012. Phil Asia Air Flight 916 was on a scheduled passenger flight from Manila, where it crashed as it landed at the Cagayan de Oro airport. The pilot miscalculated the plane's approach and fell short of the runway. 10 people died. One of them was a passenger who managed to leave the plane, but was run over by an ambulance coming to the rescue. It appears from the Civil Aeronautics Authority investigation that the co-pilot who had control of the plane's landing had less than the required flying and landing time experience, and should not have been in control of the plane at the time. The main pilot, on the other hand, had a very high level of blood alcohol at the time of the crash. Explain the causes of action legally possible under the given facts against the airline, the pilots, and the ambulance driver, who will use specifically in plead in each cause of action. A complaint for breach of contract of carriage can be filed against Phil Asia Air for failure to exercise extraordinary diligence in transporting the passengers safely from their point of embarkation to their destination. Article 1755. A separate action based on quasi-deli can be filed against the pilots because the incompetent co-pilot took control of the plane's landing despite knowing he was unqualified, and the main pilot was intoxicated while on duty. Article 2176. In this action, Phil Asia Air may be held liable for its negligence in the selection and supervision of its pilots. Article 2180. Provided that the recovery of damages against Phil Asia Air does not result to double recovery. Article 2177. The third cause of action is the criminal liability of the pilots for reckless imprudence, resulting in homicide. This is true even in the case of the passenger who got run over by the ambulance, as the crash was the proximate cause of his death. Bactalan versus Medina, GR L 10126, October 22, 1957. In this latter case, the airline will be subsidiarily liable for the civil liability ex delicto only after the pilots are convinced and found to be insolvent. Revised Penal Code, Article 103. And the question whether the ambulance and his employer be held liable for damages, the answer is in the positive. This is in accordance with Articles 2176 and 2180 of the Civil Code. There could be also a criminal prosecution for reckless imprudence, resulting in homicide against the ambulance driver and the consequent civil liability. Since the airline employee was being transported gratuitously, Phil Asia Air was not required to exercise extraordinary diligence for his safety and only ordinary care. Lara versus Valencia, GR 9907, June 30, 1958. Peter hailed a taxicab owned and operated by Jimmy Chang and driven by Hermie Cortez. On the way to Malate, the taxicab collided with a passenger jeepney, as a result of which Peter's left leg was fractured. Peter sued Jimmy for damages based on contract of carriage, and Peter won. Jimmy wanted to challenge the decision before the Supreme Court on the ground that the trial court erred in making an express finding as to whether or not Jimmy was responsible for the collision and hence civilly liable to Peter. He went to see you for advice. What will you tell him? 1990 bar. I will advise Jimmy to desist from challenging the decision. The action of Peter being based in culpa contractual, the carrier's negligence is presumed upon the breach of contract. The burden of proof instead would lie in Jimmy to establish that despite an exercise of utmost diligence, the collusion could not have been avoided. In a court case involving claims for damages arising from death and injury of bus passengers, counsel for the bus operator filed a demurrer to evidence, arguing that the complaint should be dismissed because the plaintiff did not submit any evidence that the operator or its employees were negligent. If you were the judge, would you dismiss the complaint? 1997. No. In the carriage of passengers, the failure of the common carrier to bring the passengers safely to their destination immediately raises the presumption that such failure is attributable to the carrier's fault or negligence. In the case at bar, the fact of death and injury of the bus passengers raises the presumption of fault or negligence on the part of the carrier. The carrier must rebut such presumption, otherwise the conclusion can be properly made that the carrier failed to exercise extraordinary diligence as required by law. Vivian Martin was booked by PAL, which acted as ticketing agent of Far East Airlines, for a round-trip flight on the latter's aircraft from Manila, Hong Kong, Manila. The ticket was cut by an employee of PAL. The ticket showed that Vivian was scheduled to leave Manila at 5:30 p.m. Vivian arrived at NAIA an hour before the time scheduled in her ticket, but was told that her flight had left at 12:10 p.m. It turned out that the ticket was inadvertently cut and wrongfully worded. PAL employees nevertheless scheduled her to fly 2 hours later aboard their plane. She agreed and arrived in Hong Kong safely. The aircraft used by Far East Airlines had an engine trouble and did not make it in Hong Kong, but returned to Manila. Vivian sued both PAL and Far East. Could either or both airlines be held liable to Vivian? 2003. The instant petition was based on breach of contract of Carriage. Therefore, Vivian can only sue Far East Airlines alone and not PAL. Since the latter was not a party to the contract, however, this is not to say that PAL is relieved from any liability due to any of its negligent acts. In China Airlines versus Court of Appeals, while not exactly in point, however, illustrates the principle which governs this particular situation. In that case, the carrier, PAL, acting as an agent of another carrier, is also liable for its own negligent acts or omission in the performance of its duties. Far East Airlines may also file a third-party complaint against PAL for the purpose of determining who was primarily at fault between them. It is but logical, fair, and equitable to allow BA to sue PAL for indemnification if it is proven that the latter's negligence was the proximate cause of Vivian's unfortunate experience instead of totally absolving PAL from any liability. British Airways versus CA. TR 121, 824, 1998. Mechanical defects in the carrier are not considered a caso fortuito that exempts the carrier from responsibilities. Sweet Lines versus CA. Tire brownout of a jeepney is not a fortuitous event where there exists a specific act of negligence by the carrier consisting of the fact that the jeepney was overloaded and is speeding at the time of the incident. Gentila versus Fontanar. GRL 45637. Defective brakes cannot be considered fortuitous in character. Vergara versus CA. Fire is not considered a natural disaster. Fire arises almost invariably from some act of man or by human means. It does not fall within the category of an act of God unless caused by lightning or other natural disaster or calamity. It may even be caused by an actual fault or privity of the carrier. Eastern Shipping Lines versus IAC. And before I continue with the part 2 with more example cases, if you're not yet subscribed, please go ahead and hit that subscribe button. It's free. And It will really make me feel good about myself doing this ODS. Thanks.